All right. It's January 20th, which is the first due date for the first discussion board and the first one-page response. So I will get those graded by the end of the week and back to you with the grades posted in the Grade Center. If you have any questions, I've also noticed that not everyone has turned everything in yet. So if you have any questions or concerns, or if you need an extension, that's fine. Just let me know, and we'll negotiate that one-on-one. Also, in the announcements section, I have posted a little bit of a prediction of what the next 4 weeks or so will look like. You can probably notice a pattern that it's looking like about a response page each week, a discussion board post each week, a chapter each week, and a lecture each week. So relatively normal expectations for this class in terms of work product. And you can also see the due dates for future assignments and predicted topics for those future assignments. We are in Chapter 2 now, which means that you're going to need, at this point, a copy of the textbook. If you still do not have a copy of the textbook, let me know so that we can discuss that, and so I can get an idea of when you're receiving it and how far away it is and whether it's in the mail, those types of things. Because I have not yet received an email from everyone saying they've had the textbook, and that's making me concerned. So get that as soon as you possibly can. We're already in the second week. Let's go ahead and discuss the material of Chapter 2. I'm going to run through some basics of international law since that's the topic of this chapter, and we'll conclude by talking about comparative law and the ICC and ICJ. You can see on Blackboard right now that the discussion board topic for Chapter 2 is specifically the Rome Statute and the International Criminal Court. So I'll cover that in some with a little bit of detail. And the one-page response paper is about comparative law. So let's just jump right into that. When we're talking about international law, one of the first things that we have to realize is that we're talking about both international agreements between countries as well as the domestic law within each specific country that might have international ramifications. So obviously, just as a point of example, when we used the Mexico example in the last discussion board post, if you're doing business from the United States with a Mexican market of some kind, you're interested in three things: American law that applies to those transactions, Mexican law that applies to those transactions, and any international agreements or accords or contract requirements or labor requirements that are the result not of American or Mexican law, but the result of international agreements, whether they're bilateral or multilateral, between those two countries. Okay, so we're interested in all three things: the international law that applies to the situation, as well as the domestic law of the two countries involved. Or if it's an even bigger transaction involving more than two countries, then every one of the individual parties. When we're talking about international law broadly, we're talking about the conduct between nations, rules that regulate their relationship, rules that regulate the way that they do deals with each other. It might even be the way that they fight wars against each other. They might agree that they won't use certain tactics, right? Chemical weapons, torture. It also applies to disputes between individuals within those countries. So if there's an international dispute between a multinational corporation located in the United States and their vendor in another country, then international law may apply. So we're talking about all these disputes, whether they be governmental or private, or even on the individual level. So a business, a person, international law comes into play when we're talking about things that have nothing to do with business: international adoptions, international marriages, all of those kinds of things come into play. And so this makes it a very, very large body of law. It makes it a vastly difficult subject area to specialize in. Okay, Applies to everything from airline regulations to international trade, arms control, protecting the environment. No one country obviously could control greenhouse gas emissions by themselves, right? It's going to take cooperation, and cooperation on the international level generally needs to be enforced through some type of international agreement. So that's just to emphasize the broadness of this topic of discussion. We divide international law into two basic categories. There's public international law and private international law. Public, as a rule of thumb, generally has to do with a government. Okay, so when we're thinking about the North Atlantic Treaty Organization, known as NATO, which is an alliance of countries that was originally developed to combat the bloc of countries that the Soviet Union put together during the Cold War. That's definitely public international law, right? Agreements between countries that they'll have each other's back if they're ever attacked by another nation. Other public international law that has to do with government, the United Nations, right? That is the primary meeting place for international accords, negotiations, agreements, a place where nations can come together to discuss international disputes and ideas of concern. Okay, disputes that have to do with territory. So if the United States makes a treaty with Canada that says you have this half of one of the Great Lakes and we have the other half, that's definitely public international law. That's a border dispute. It's definitely having to do with governments. Making war and making peace. Any peace treaty is public international law. The Geneva Conventions that put limits on countries in terms of what tactics they may use in warfare. That's public international law. Private international law is generally the international law that might be created by governments or agreed to by governments, but the topic of that international law is not governmental. Okay, so this is international law that involves the conduct of individuals, international corporations or organizations. It involves the dispute resolution process for private parties. Okay, so international adoptions, international probate, or wills and trusts, or banking, or shipping, or sales, or most of the stuff that's covered in our textbook for international business transactions, international law. A lot of this is going to be private international law. Okay, the types of accords that tell, for example, public airlines what kinds of safety regulations they're going to need in order to transport people across borders and land at international airports. That's all private international law. And it's far more well developed in some sectors of economies than it is in other sectors. I would say there's probably a lot more international law on banking and buying and selling than there is on certain other things that are more obscure. Okay. Sources of international law generally come from three different places. So three different main sources of international law. The first is pretty easy to find. It's international treaties and conventions. It's the stuff that's written down, in other words. International protocols, agreements, treaties, accords, the UN Charter, anything that's written down and then signed by both countries and then ratified by both countries, that's a treaty. That's something that countries have agreed to in writing. That's just number one, which is another way of saying the other two categories are not necessarily that set in stone or that easy to find or that easy to figure out. Okay, so they're the more controversial areas of international law. So this second category is customary international law. Customary international law, the best way to describe it is evidence of past practice. Okay, so even if it's not written down in a treaty, If you can point to something that shows that countries have acted this way for a long, long time when they're doing this type of transaction or handling this type of dispute, you can call it customary international law. The Latin phrase is opinio juris. Is it in the opinion of jurists across the globe that this is the way we do this? Okay. You could say that customary international law covers things like genocide, for example. We generally agree as a world community that that should be illegal and that it is illegal, right? Now, we might have any number of treaties around the world that ban genocide, and we of course do. But even for countries that are not party to those treaties, we could say they might still be bound by customary international law. They might still be bound because it has become such an entrenched international norm. Okay. And that might open them to some sort of dispute resolution or prosecution if they were to violate that norm. And then finally, the last source of international law are principles recognized globally in domestic courts. So within each individual country, if their individual domestic court practice, just as a matter of their past practice or otherwise, tends to recognize international principles, then that might be something that we consider international law. So if you have a domestic court that is willing to look at language from a treaty, not because the treaty exists and is binding on that court, but just because it's evidence of something that we consider important on the international scale, that can be considered a source of international law. Okay? Among the treaties, we generally have two types also, bilateral and multilateral. That's going to be the easiest distinction we make in this class. A treaty between two countries is a bilateral treaty. So the Treaty of Paris between the United States and Great Britain that ends the Revolutionary War, we have a bilateral treaty. On the other hand, a multilateral treaty involves any number of nation states, 3, 4, 5, 100, 200. So the Convention Against Torture or the International Convention on Human Rights, any number of conventions, especially that originate in the United Nations or other international bodies, the treaty that creates the World Trade Organization, the International Criminal Court. These are all multilateral treaties. It would be hard to say which is more common, bilateral treaties or multilateral. If you just counted up all the treaties in the world, almost certainly you would see more bilateral treaties than multilateral because every one individual country might have a bilateral treaty with any number of other countries for multiple reasons. For example, the United States might have a treaty with Britain for the purpose of criminal extradition. So if one of our criminals flees to that country in order to escape the prosecution of our courts, let's say he committed an American murder and then moved to London in order to avoid us, we can say, hey, London, please send him back to us so that we can prosecute him in Denver. We have a treaty on that, right? A treaty on extradition, but we might have a separate treaty with Britain on trade. We might have a third treaty with Britain on the way that we conduct certain international diplomacy, right? So bilateral treaties almost certainly outnumber the number of multilateral treaties, just because of the law of numbers, just because of the number of countries and the nature of the way that those treaties work. But multilateral treaties end up getting a lot more discussion in classes like this because it's going to be those multilateral treaties that are on the types of topics that we're covering in this class: international trade, international business transactions, tariffs and taxes on those international business transactions, the international organizations that conduct arbitrations and make decisions on contract disputes, sales disputes, fraud in those transactions, those types of things. So we're mostly going to be talking about multilateral treaties in this class. In terms of some language, some people sometimes ask, what's the difference between a treaty, a convention, and a protocol? They're all the same thing, okay? A convention is just a type of treaty. A protocol is generally a word used for a narrower category of topic than a convention. So an example of a convention is the Convention Against Torture, just a very broad topic. We think torture is bad. Here's some general ideas of what we think qualifies as torture. And then you might have, 100, 200 countries signing that treaty saying, okay, we agree that we're not going to do this list of things. A protocol is usually a far narrower issue. A protocol might be even so narrow that it defines a specific number of something. The Kyoto Protocol comes to mind as one of the international agreements where countries agreed to limit their emissions of carbon dioxide into the air, generally over a far narrower issue. You could say a convention would be about the environment and a protocol would be about, emissions into the air of carbon dioxide. So protocols generally narrower, conventions generally broader, but ultimately treaties, conventions, protocols, they're all generally the same thing. And some of them are even called statutes. It really just depends. The language can sometimes get prohibitively broad in terms of trying to nail down exactly what it means. But if it's an international agreement, it's a treaty. And we can just stop there. If it's an international agreement, it is a treaty. Okay? Other language. What does it mean if you were to try and split the difference between signing a treaty versus ratifying a treaty? Now, this gets confusing to some people, so let's just put it in the most simple terms. Signing means almost nothing. Signing a treaty means that you intend maybe to ratify it later, or that you would love as if you're the head of state of a country, President of the United States, Prime Minister of Britain, Chancellor of Germany, you might sign a treaty in order to express your intent to try and ratify it, or your intent to treat the negotiation process in good faith. Maybe you want to show up to the negotiation process and be a part of the development of the treaty itself. Signatories, you perform that role. It's basically a good faith promise, but it doesn't actually mean a whole lot. Ratification is what means a whole lot. Ratification is the process each country might have for the approval of a treaty. So in the United States, let's say that we have a bilateral treaty that we're negotiating with Russia on nuclear arms. Let's say it's part of the treaty is that we won't have more than 50,000 nuclear weapons at any given point in time. We'll both kind of have a upper level cap that limits the total number we're allowed to have, just for safety reasons, right? You might sign that treaty in order to demonstrate your good faith as a country to then ratify it and make yourself bound as a country to its terms. And a president might sign that treaty, and then there's a new election and a new president, and they might renounce that signing of that treaty and might never submit that treaty to the United States Senate for ratification approval. Okay, so signing doesn't mean a whole lot. Domestically, the way that we ratify treaties is to submit them to the United States Senate for approval or disapproval. Now, a treaty will need a majority vote in the United States Senate to receive ratification. The majority vote might never happen for any number of reasons. It could go to the Senate and then just be, not receive a majority. Or it might never be submitted to the Senate at all. Or it might be submitted to the Senate and they just decide never to take it up, never to bring it to the floor for an up or down vote. Okay? But the only way that we're ever going to become party to a treaty is if it receives a majority vote in the United States Senate. Okay, after it was signed by our head of state, our president. Okay. And then abrogation. Abrogation is either the expiration or the explicit renunciation of a treaty by all of its parties. So a treaty that's in existence can be abrogated once both parties say, we both agree that this treaty shouldn't exist anymore, or it can be abrogated by its own internal wording. If you had a treaty that said this treaty shall only last 20 years and you reach the 20th year, the treaty ceases to be enforceable. Okay. And enforcement becomes a tricky issue in international law. It's probably the most tricky issue. As hard as it is to get countries to agree with each other on the content and the wording of a treaty, it's even harder for countries to agree on who actually forces countries to abide by those words and who determines whether or not a violation has taken place and whether or not it meets the actual letter of the treaty itself, right? A country might say, well, we followed the spirit of the law, we followed the intent of the treaty, and so we consider that sufficient. And the other country that's a party might say that's not sufficient. You didn't follow it as strictly as we thought it was supposed to be interpreted, right? Who makes that decision? Is there a court somewhere that makes that decision? Depends on the treaty. Do countries just negotiate that amongst themselves once there's a dispute? Depends on the treaty, okay? In terms of international business law, probably the most important principle is uniformity. What we are interested in when we're making foreign investments, whether it be in the form of a franchise, whether it be foreign direct investment that you read about in Chapter 1, or whether it just be international business sales for domestic products by sending it to a foreign market, to a foreign distributor. The most important thing is going to be the uniformity of the laws that apply. So one of the reasons that we end up getting a lot of international agreements on the topic of international business is businesses want predictability, okay? Banks that do foreign investment want some type of assurance that they don't have to do a different type of transaction with every different country they're dealing with. They would love to have the same type of contract structure, to have the same type of contract terms, to have the same type of expectations between buyers and sellers and dealers and creditors and debtors and all the intermediaries that might go into the transaction. They also want to make sure that if there's a dispute about payment, that those disputes are settled in an orderly fashion, in a predictable fashion, instead of one that might be arbitrarily made by one government in order to spite another government. It is really the business community that's been driving the, for lack of a better term, the lobbying of governments for the creation of these international agreements, okay? And it's really spiked over the past 25 years because it's really over the past 25 years or 35 years that we have seen a huge spike in the total amount of international trade, okay? We've seen the process of globalization. Companies finally seeking, once they're established domestically, usually, to expand their market and expand their profit by creeping into new markets. Just as one example, the Philip Morris Company, which I think renamed itself to something else, which is known for making cigarettes, started hitting a brick wall in the United States because of increased regulation and increased taxation on the manufacture and sales of cigarettes. So, and ultimately that also led to a lot of advertising campaigns that discouraged the smoking of cigarettes because of the health risks. And their market share steeply declined in the United States. They basically fell off of a cliff. People stopped buying cigarettes, and for those that continued to buy, they were either smoking less or the purchases were more heavily taxed, the production was more heavily regulated, and America just became not really the best market for that product. So what did those cigarette companies do? They decided on a whole new business strategy. Instead of selling in the United States, where we're heavily regulated and where people are starting to wake up to the health concerns, they started marketing extraterritorially. They started marketing to South America. They started marketing to Eastern India and Asia and Africa. And now we have some companies in the United States, especially cigarette companies, that make most of their money from abroad as opposed to domestically. Okay, so that has it's trends like that that have spurred a lot of international organizations and international governments to create a predictable set or a predictable body of international law that regulates these transactions. Things like the World Trade Organization, things like contract rules. We also know that cooperation between international governments is necessary to protect certain interests. We talked, for example, last week about intellectual property, right? Patents, copyrights, those types of things. If you're worried about your product being stolen and then pirated online or otherwise, then you want governments to cooperate with each other on these things and to, as close to uniformly as possible, enforce these rules in their domestic courts. Okay. You also want, in the course of international trade, a uniform code for not just things like contract provisions, but safety, right? If you're going to send someone overseas to produce steel or to blow glass or whatever it is that you're wanting to manufacture, you might be interested in safety laws. You might be interested in especially food safety laws, human rights, okay? So that's another reason that a lot of this has continued to develop, and especially over the past 25 years. And finally, in terms of uniformity, you want consistent arbitration of disputes. A predictable set of rules for how you're going to decide who was at fault by how much, and how much one person owes another person, instead of having to go through a multiplicity of different domestic courts. Okay? So that's been part of the reason that we've developed this area of law internationally so quickly over such a short period of time. International trade's just, it's not a new phenomenon, but it's spiked so much so recently. Three different types of international business criminality, just real quick. This isn't too critical to the assignments in this section, but important to know anyway. In terms of international business criminality, you have three categories. The first is organized crime, which covers things like smuggling, human trafficking, counterfeiting of money or other products, piracy, not just piracy on the high seas, like the hijacking of cargo ships, which does still happen, especially off the coast of Somalia, off of Eastern Africa and the Seychelles and the Persian Gulf area, but also electronic piracy or data piracy, okay? The selling of intellectual property or the taking over of intellectual property that's not yours. Money laundering, cartels, all that falls under organized crime, okay, which is international business crime. And then there's not necessarily organized crime, but there's just internal business crime, things like fraud, things like extortion, breaking an export control law or a customs law. There are rules in certain countries about what can be taken out of the country, what can be brought into the country. And those laws come from a lot of different areas of thought. One example includes whether or not you're, for example, bringing one type of insect from one country to another that might, if it got loose, become an invasive species and destroy their ecosystem, right? So customs laws are about things like that, but they might also be about drugs. It might be a drug that's allowed in one country but not in another. It might be a pharmaceutical that's allowed in one country but not in another. Maybe something's more heavily regulated in one country. One of the interesting things that happens now, if you go over to London and you want to come back to the United States, there's these little chocolate candy eggs that have a toy in the middle of them that you can't bring back because the United States says that you can't have toys in food, and in Britain they haven't regulated that. So it gets down to sometimes some very, very narrow categories. But those are just regular business crime, okay? Fraud, customs, tax evasion, antitrust laws. Antitrust laws are rules about price fixing, covenants not to compete with other companies. Best example I can give of that is if you're doing business and you meet the CEO of another company and you both agree that you'll just, since you're the two major competitors in that market, that you'll just both raise your prices really high so you don't have to compete with each other. And since you're the only company people can turn to for that product, they'll have to pay that high rate. You might be breaking an antitrust law if you make that agreement. Okay. So that's just the category of regular business crime as opposed to organized crime. And then other international business criminality would fall under the last category, which is kind of beyond the area of business. Pure criminality. Pure criminality would be something like committing some type of horrible act, murder, genocide, a violation of human rights, torture, those types of things, either in the course of or outside the course of the conduct of your business. Probably the most common thing that falls into that category are things like demanding bribes in return for doing business with someone. Okay. Types of jurisdiction. Your book lists a lot of different types of jurisdiction. The only thing that I think is worthy of conversation there is the distinction between universal jurisdiction versus domestic laws that have extraterritorial jurisdiction. So let's just draw a distinction here. Universal jurisdiction applies to crimes that the international community would agree are just universally things that anyone can enforce at any time. So let's say you have actual piracy, right? Or you have actual genocide happening somewhere in the world. Generally, countries don't mind so much if any particular country decides to prosecute that. Okay, so in the course of your shipping a shipment from one country to another, you encounter someone who tried to hijack your ship. That's fine. Either country can prosecute that, or any country, even if they weren't involved in the transaction, right? That's when we consider something universal jurisdiction. Certain crimes any country can prosecute. Extraterritorial jurisdiction of a specific country is a little more limited. It's where a country enforces its laws outside of its own borders. So if you're an American citizen and you go commit a crime in international waters, not within the territory of the United States, but you go on a cruise ship and it's crossing the Atlantic Ocean, and in the course of that travel you commit a murder, okay? First of all, you've committed a moral issue, right? We all can probably agree, because of the golden rule, that's a pretty bad thing to do. But the next question is, who gets to prosecute that murder? Is it the country they left from? Is it the country they're going to? Is it the country whose flag flies over the ship? Well, that's a question of international law. But it's going to be a question of extraterritorial jurisdiction. Very likely, you're going to have multiple layers. Usually, the country to whom that individual owes citizenship is going to have jurisdiction over that murder. Okay, so if you're an American on a cruise ship crossing the Atlantic, America could prosecute you for that murder. Generally, the country who flies the flag over that ship, whichever country has custody of that ship, is going to have some extraterritorial jurisdiction. And then maybe the nationality of the victim might come into play. The country who has the rights of that person as something that they care about might also have extraterritorial jurisdiction over that. And then it's just going to be up to the different parties to decide who's going to prosecute. Okay. Extraterritorial jurisdiction doesn't just apply to situations like that, but it can also apply to employment laws. It can apply to acts of treason. So if you were to leave the United States and go support a foreign country that is our adversary, okay, or if you were to leave the United States potentially and go join Al-Qaeda in Afghanistan or Pakistan, then you might be committing an act of treason, or you might be committing something that our laws could forbid and then prosecute you for. But to wrap up that section, let's talk about something that I'm grading you over. The discussion board forum for this week has to do with international courts. We have two major international courts. We have the ICJ and we have the ICC. What's the difference? Well, let's start by saying that both are severely limited. Okay? As a general rule, countries don't like to give up their sovereignty. Sovereignty is the ability of a country to enforce laws. And anytime you empower a third party, an international organization, to enforce laws, that chips away slowly but steadily at nation sovereignty. The ability of countries to enforce their own laws ends up being something that this independent organization or this international court does instead, at least for a certain category of crimes, right? For both the ICJ and the ICC, this has been the problem. Countries don't want to be parties before those courts. They far prefer the immunity that they get by being independent countries. Okay? So, for example, the ICJ is almost ridiculously weak. Okay? And it's not just me saying that. Take a look at the section in your book about the ICJ. Jurisdiction is entirely 100% voluntary. Voluntary. A country does not have to agree to be a party before the court. A country cannot be forced to be a party before the court. And since the ICJ is about disputes between nations, well, if the United States wanted to bring, let's say, Mexico to the ICJ to say, you did something wrong. You've been charging taxes on our exports that you weren't supposed to, or you've been holding our ambassador a prisoner for some reason that we don't think is fair. Well, we say, hey, Mexico, please come to the ICJ with us so that they can determine who's right and who's wrong. They don't have to agree to that. And the ICJ can't send some type of enforcer to force them to be a party to that. Okay. In the ICJ, you have 100% voluntary jurisdiction. Sometimes parties agree to it just because it's a matter of convenience. It's good to have a forum for dispute resolution. But then we also have this sort of nasty little history of getting judgments and then them not being enforced. Okay. We went to court in the ICJ with the nation of Iran decades ago about the holding of hostages. We've gone to court with the ICJ for many different things that haven't been enforced, whether it be fines that the ICJ declares are appropriate, whether it be injunctions for a specific type of action, like the releasing of a hostage or the proper treatment of a diplomat. The ICJ doesn't necessarily have its own internal enforcement mechanism to go and force those orders to be complied with. Okay. One thing to note about the ICJ is disputes before them have to do with nations and not individuals, even if those cases encompass individuals in addition to nations. So an individual, a person, a human being, can't just go before the court and say, I'd like to sue a foreign country. It would have to be the country you're from that does that on your behalf. Okay. Generally, the types of cases that are brought before the ICJ are governmental anyway, usually not involving individuals unless they are agents of a government. So we're talking about border disputes, we're talking about human rights disputes, detained diplomats or hostages, those types of things. Okay. Almost universally seen as a weak court with little enforcement. Let's contrast that a little bit with the ICC. The ICJ exists under the UN. It's the judicial branch of the UN. The ICC is its own independent court. It has jurisdiction only for certain criminal acts. Genocide, crimes against humanity, and war crimes. That's it. The International Criminal Court does not do any other type of dispute resolution, and it doesn't do anything but those three crimes: genocide, crimes against humanity, and war crimes. Okay. It's its own independent court, and it's comprised under the treaty that we call the Rome Statute. Okay. It has 122 parties. It's relatively recent construction. Okay. It was developed so that there would be a way to prosecute people who commit genocides, people who violate, basic rules of human decency and dignity during wartime. Oftentimes the use of chemical weapons or biological weapons in warfare. That's generally what we're talking about when we're talking about the Rome Statute. 122 parties, but here's the important part. Among the countries that are not members of the Rome Statute, have not ratified it, and have not consented to the ICC's jurisdiction are the United States and Russia and China and Iran and India and a lot of major countries around the world. Now, you can ask yourself, why would a country not want to be a party to the ICC when obviously they exist for such a good reason? They prosecute genocides. They prosecute crimes against humanity, things like slavery, things like torture, okay? Things like gassing people in a war with some type of, gut-wrenching, horrible chemical weapon. Of course, those are noble intentions. The question that you have to ask yourself is, do you trust the court to make quality decisions and for it not to be politicized in some way? And then second, do you trust that your country won't end up being a particular target of the court? Okay. Are you a country that fights wars often? Might one of your actions in a war come under scrutiny by that court? Okay. There are those in the United States who, because of the history of the United States and our very common involvement in international conflicts, who become concerned that if we were to sign the Rome Statute and then ratify it and become consenting to the jurisdiction of the court, that there are other countries that would try and haul our chief executives, our presidents, our generals before the court for things that we see as legitimate wartime actions. Think about the use of drones abroad, the unmanned aircraft that might drop a bomb on someone considered to be a terrorist in Yemen or Pakistan or Afghanistan, right? We might consider that to be a perfectly legitimate wartime action. Another country, like, for example, the country where the bomb landed, might disagree and say, nope, that's a war crime. Look at the civilian casualties of that bomb, right? And if they think they can win that argument before the court, they might bring it. And they might seek to have that particular American official, whoever the high-ranking person was that made that order, right, arrested and then prosecuted under that court. So there's some hesitancy on the part of especially some of the most major countries around the world to become parties before the ICC, just because they fear that the construction of the definitions of those crimes are too broad. There's also no statute of limitations, which is to say you can be prosecuted for anything at any time for anything that you have done over the course of history. And there are some other procedural issues that some people have with the ICC, including the fact that there's no right to a jury trial. Okay, things that we have become accustomed to as a protection. Under American criminal law, things like a protection against the admission of hearsay evidence, the right to a jury trial, the right to cross-examine witnesses, those types of rights might not exist at the ICC, or at least might not exist to the extent that we wish them to. And so there's some questions about the potential fairness of the court, or at least the willingness to trust the future fairness of the court. Even if we think as currently constituted it might be fair-minded, once you become a party to the treaty, what's to say that some future iteration of the court might not become skewed, or that future judges on the court might not end up coming from countries that don't align with your country's interests. Okay. So that's why there's only 122 parties out of almost 200 countries around the world. And it's also, those are some of the reasons that some countries have decided not to consent to their jurisdiction. All right. Finally, just to talk about comparative law for a little bit. And this is going to end up as the topic for your one-page response paper, at least part of it. In terms of comparative law is just a phrase that means comparing legal systems around the world. Okay, so we know that not every country does law the way every other country does. Some countries have far greater emphasis on court decisions and using those as precedents in future court cases. And some countries like to write everything down and have incredibly comprehensive rules, exceptions to those rules, exceptions to the exceptions to those rules, all written out at length, okay? Book length or book upon book upon book in some cases. That like strict codification of all of their rules instead of mere judicial decision making that invents those norms. Okay. You could teach a whole class on comparative law. In fact, you could have a whole major with layers upon layers of classes that explore different types of laws and different types of legal systems, both historically and currently around the world. Japan is mentioned in the book as one of the countries that has seen an evolution in the way that it handles legal disputes. Of course, starting out as sort of a communitarian, almost, if you could compare it to an economy, almost like a barter system of legal justice, where the community would just come together and do what they see fit as the response to a situation. You know, until Japan becomes open to international trade and they start doing significant international trade with the West in the 1800s. In the 19th century, they sort of copy and paste a lot of European concepts into their own legal system. And then, of course, following World War II, after Japan is in part reconstructed by the United States, they adopt some of our legal jurisprudence. And so you have some countries like Japan that are just an amalgamation of many different types of legal structures around the world, including both traditional values, civil law, as well as common law. But for the most part, even when you can find the unique countries that have hybrid systems, for the most part, we can compare most of international domestic law into two categories. You can have civil law countries and common law countries. So let's draw the distinction here. What are we talking about when we talk about a civil law country? This gets confusing really fast, so I'm going to break it down about as easy as I can. Here in the United States, civil law is a whole different term. Okay, when we talk about civil law in the United States, we basically mean everything that's not criminal law. So criminal law is law that involves the government imposing a penalty on you for criminal conduct. If you go and stab a person, you might be arrested, right? That's criminal law. In the United States, what we consider to be civil law are things like divorces and marriages. Has nothing to do with the government. It's agreements between parties, right? Or if somebody rear-ended my car and I want to sue them for the damages, that's a dispute between me and them. The government might help me resolve it by declaring some type of appropriate judgment or payment, right? But it's going to be a civil dispute. On the international stage, the phrase civil law is differently used. It generally is seen as a legal system of codification of laws, okay? It means public law, tracing its origin all the way back to Roman codes of conduct, going back to the Justinian Code, okay, where governments attempted to write down everything that they planned to enforce upon their citizens, okay? So civil law in the international sense, if you're in a civil law country, you're in the type of country that has very long codes of regulations, very long lists of rules that you must follow. And their entire system of jurisprudence is going to be about strict adherence to those written down rules as opposed to looking at customs. Okay. Um, the general rule is, you know, you're in a civil law country when you can find the rule in text form. You can Google it. You can go look at a law book and find the law. Okay. This contrasts pretty deeply with common law. The United States is generally seen as a common law country, or at least maybe potentially a hybrid of both. Britain is generally seen as a common law country. And the difference here is that we're not too big on writing down specific rules. We might have some laws, but even the evolution of the interpretation of those laws is going to be on the basis of past judicial decision making. Okay? And this is called case law. When a court makes a decision, let's say, for example, it's a decision about a divorce. Okay, one party wants to be divorced from another party. Well, is that allowed? Do you have to? Are divorces for cause, or do you live in a country where you can get divorced for no reason at all? In a lot of common law countries, that might not be a rule that's written down somewhere. So what courts would do is just look back to prior decision making. Do we require that you have to have a reason to get divorced, right? Do we require that you make attempts at reconciliation before you're qualified for a divorce? Those judges would just look back at a court case decided 5 years ago, 10 years ago, and see how that past court handled the situation in order to determine how the current court should handle the situation. So they're not looking at legislatively passed laws. They're just looking, really, for the most part, at past conduct of prior courts. Okay, so that's common law. It is a little bit more loosey-goosey. It is based on past decision making. And in common law countries, that past decision making might sometimes be binding on the future court. We call that the principle of stare decisis. It's a Latin phrase that basically means deference to the first, deference to the prior decision. This is one of those things that might not be entirely ironclad. A court might overturn a decision of a prior court. We've done that, for example, in the United States. We used to have, in terms of race relations and segregation, the old rule was the rule designed in the late 1800s in the Plessy v. Ferguson case, where separate but equal was permissible. So long as you have equal accommodations, you might be able to have a rule that separates the races. So different train cars, one for whites, one for blacks, that type of thing, which was overturned only about 5 decades later in Brown v. Board of Education, which was a court case that said separate but equal is no longer the law, that integration was required at all deliberate speed. Okay, so you have school integration, train integration, no more separate but equal, just equal, right? But the whole point there is, in a common law country, that decision making is not made legislatively. It is not a written down rule, or at least not always. Okay, it is something that evolves as the courts look at prior decisions. Okay. So for the most part, when we're talking about common law countries, we're talking about countries like the United States, Britain, a lot of former British subjects, Canada, Australia, India, a bunch of countries in the Caribbean. And then when we're looking at civil law countries, generally we're looking at countries like Germany, a lot of European countries that aren't Britain, France, for example, with the Napoleonic Code, have a lot more elements of civil law than they do common law. If you're in a common law country, there's a lot of emphasis on adversarial decision making in courts, one side duking it out with the other side, a plaintiff and a defendant, trying to convince the judge who's right. In a civil law country, as opposed to common law, you might have the judge be more empowered to make inquiries on their own so that they can see whether or not a specific part of the code, specific law, applies to the situation in the way that they need to figure out if that law was violated or how it needs to be followed. Okay. That brings us to kind of the last area of comparative law, which is religious law. Okay, and the part of this that your book covers is Islamic law or Sharia law. If you're doing business in a country with some type of religious law, you can toss out of the window all the principles we were just talking about. Civil law or the strict adherence to specific legislation, common law, the adherence to prior decision making and using those to inform current decision making. Get rid of it all. If we're talking about religious law, and really the only major world religion that has developed its own legal doctrines that bind individuals in a non-secular way is Islam. And this is basically religiously inspired legal doctrine or legal principles that might bind individual conduct, both criminal and civil. So everything from marriages to thefts, right? And your religious principles might be enforced in governmental courts, which is something a little bit foreign to most Americans, where we have separation of church and state, right? Where our Constitution guarantees that no government is going to enforce one religion's rules on the rest of the population. Not always the case in a theocracy or a country that's governed under religious principles. Okay, in Islam, you might garner those religious principles from the Quran or a different series of edicts known as the Sunnah, and there's often very little adherence to prior precedent, the way that you would see in a common law country. In fact, the rulings are not even often written down. Usually it's kind of left up to each individual court to determine whether or not they think the alleged infringement or the alleged bad act was a violation of religious principles or religious texts. Okay, so those interpretations might vastly differ. It might be a far more strict interpretation if you're in Saudi Arabia, where you have relatively strict religious rules. It might be different than the interpretation in Egypt or the interpretation in Pakistan, which has some religious courts and some secular courts. It really depends on which country you're in, but it doesn't really strictly adhere to the binary concept of civil law versus common law. Sharia is quite a bit different and quite a bit more unpredictable because of the interpretations of religious texts varying so widely depending on whether you are interpreting them liberally or interpreting them conservatively, or interpreting them as a member of some subsect of Islam. All right, that's the lecture for this week. If there's any questions, always feel free to email me, mdavis@se.edu, or call me, 580-745-2392. Go ahead and take a look at the assignments. The due date is, once again, a week from today, the 27th, which falls on a Wednesday. And I look forward to grading the information that you sent me today, and wish you the best of luck. Thank you. Bye.